Lawyers live by one ironclad rule. When the judge tells us to do something, we do it. That doesn't mean we always like it, and it doesn't mean we won't try to find other arguments to achieve the same ends. We're kind of like teenagers in that way. But at the end of the day, we roll our eyes privately and comply with what the judge tells us to do. And when we disagree with the ruling, the right thing to do is obey the judge's order and appeal until the last court tells us no. And because thousands of lawyers follow this basic rule every day, the rule of law survives. But right now, the rule of law is in peril because President Trump has decided he doesn't have to follow the court's orders he doesn't like. Sort of. It's complicated. He's refusing to comply, but saying that they are complying.
On Air Force One last night, he was asked, did his administration violate the judge's order?
I don't know. You have to speak to the lawyers about that.
But it seems we may have the clearest case of the executive defying a direct court order in American history. And it looks like things are only going to get worse. Now, as we've already explained, the ACLU got wind of a Trump plot to massively expand and fast-track deportations without a fair legal process. The Alien Enemies Act of 1789 is a controversial law that purports to allow the government to deport foreign nationals during wartime. But Trump has invoked this act to justify deportations during peacetime. And Trump asserts that the act allows him to deport certain immigrants on the grounds that they are members of a Venezuelan gang. Of course, so far all this has happened without any due process whatsoever, meaning that we don't know that any of these people are actually members of a Venezuelan gang. And as long as the president says that they are a member, they can be deported, actually renditioned to a foreign country that they're not even from. And that means that it's possible that even American citizens could get swept up in this whole process. Which is why we spent an entire video going over how terrible all of this is. But the ACLU filed an emergency lawsuit asking a federal judge to stop the renditions. On March 15th, U.S. District Judge James Boasberg issued a 14-day temporary restraining order halting the deportation of over 200 Venezuelan immigrants. The judge even told the government that if the planes were in the air, they needed to turn around. And despite that order, the administration proceeded with the deportations. At a hearing, the DOJ lawyers asserted that Trump had the power to deport immigrants and that he could keep his reasons secret from the court. And the judiciary exists to interpret and enforce the law, ensuring that the executive and legislative branches operate within constitutional limits. But the Constitution contains a potentially fatal flaw. It doesn't give the courts a way to enforce their orders. That's why the system depends on all of us recognizing the court's authority. And when the executive branch defies a court order, it effectively declares that the judicial authority is meaningless, potentially eroding the rule of law. And it seems the Trump administration's actions have finally triggered the constitutional crisis we've been dreading all along. So today we're going to talk about what happens if the president ignores a direct court order. Schoolhouse Rock laid this all out for us.
No one part can be more powerful than any other is. Each controls the other, you see, and that's what we call checks and balances.
And that's a pretty nifty system when it works. But Trump is theoretically not the first president to face off with courts. Presidents like Andrew Jackson and Abraham Lincoln are often cited as examples of leaders who defied judicial authority. However, the myths surrounding their actions don't quite match with the reality. What Trump is doing right now is putting us in completely uncharted waters. For example, in Worcester versus Georgia, the Supreme Court ruled that the state of Georgia could not impose its laws on Cherokee land. And that case contributed to the horrible episode in American history known as the Trail of Tears, where thousands of Native Americans were forcibly relocated. President Jackson criticized the court's ruling, and he allegedly said that Chief Justice, quote, John Marshall has made his decision, now let him enforce it. But this quote is almost certainly apocryphal. Most articles about the presidency and the rule of law conclude that Jackson himself defied a court order, probably because of this probably incorrect quote. Jackson supported Georgia's defiance of the Supreme Court, and he did not send the marshals to enforce the Supreme Court's order, but it's a myth that he defied the court himself. Similarly, Lincoln is often thought to have defied the courts when he suspended habeas corpus during the Civil War. In the case of ex parte Merryman, Supreme Court Justice Roger Taney considered whether to grant a habeas petition by John Merryman. Taney was sitting as a circuit court judge at the time, so this wasn't a Supreme Court case, but the military accused Merryman of operating a secessionist terror cell. When he was arrested, he filed a petition for habeas corpus, and Taney ordered the general in charge of Fort McHenry to appear at the hearing and to bring Merryman to the hearing itself. The government suspected Merryman of blowing up train tracks to prevent Congress and federal officials from reaching Washington, D.C., which would have cut D.C. off from the rest of the Union and could have altered the outcome of the Civil War. When a U.S. Marshal tried to enforce the order to bring Merryman to court for a hearing, the military refused him entry. Judge Taney ruled that the government should have brought Merryman to court, but he never directed President Lincoln or the general who had custody of Merryman to release him from confinement. Instead, he wrote an opinion that Merryman should be released. He asked the president to consider it, and then he served the opinion on President Lincoln. The entire case was over in 48 hours, and historians don't know if Lincoln was aware of the proceedings while they were happening. Merryman was eventually released on bail and wound up dragging out his treason trial until after the war ended. But the point is that Presidents Jackson and Lincoln did not directly ignore court orders in the way that the Trump administration seems to have been doing in these deportation cases. Now, before we get into the court's options, it should be noted that it's not always easy to determine if the government has violated a court order. Sometimes the government violates the spirit of an order without violating the letter of the law itself. And there are two recent examples of this. On March 6, President Trump issued an executive order suspending the security clearances for the law firm Perkins Coie, limiting the attorney's access to federal buildings. U.S. District Judge Beryl Howell granted a temporary restraining order against the enforcement of this order. But Trump then issued an executive order targeting another prominent law firm, Paul Weiss, using the exact same language enjoined by Howell. Now, we can argue that the Paul Weiss order will be enjoined for the same reason that the government should not have tried it again, and that's true, but Judge Howell's order doesn't apply to other law firms. As a side note, this is one of the reasons you should not be able to pass a bill of attainder in Congress or create effectively a bill of attainder by executive order either, but that's a topic for another video. But in any event, the two executive orders are different. One targeted one law firm and the other targeted a different law firm. So the first TRO doesn't apply to the second executive order. And Trump seems to be playing the same game with transgender people in prison. In January 2025, President Trump issued Executive Order 14168, mandating, among other things, that transgender women incarcerated in federal prisons be transferred to men's facilities and denied access to gender-affirming medical care. On February 25th, federal judge Royce Lambeth granted a preliminary injunction blocking the transfer of these transgender women to men's prisons and the termination of their hormone therapy. The Bureau of Prisons subsequently proceeded with transferring other transgender women to men's facilities, but kept the three named in the TRO where they were. While headlines said that the Trump administration ignored a court order, this probably isn't true. The administration complied with the letter of the order by not transferring the three named women to a men's prison, but now they face additional lawsuits on the same grounds related to all the other people that they transferred. Now, while the courts have the right to say what the law means, and that goes back all the way to Marbury versus Madison, the Constitution doesn't give courts a clear way to enforce orders against a rogue president who refuses to follow the spirit of the orders or just outright ignore them. Now, if you are illegally renditioned to a foreign country, you're probably going to want a good lawyer. But if you want a great lawyer, let my firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team, so click below. So when the government arguably disregards a court order, judges usually start by clarifying their orders and giving the government a chance to comply. This is happening right now in dozens of cases involving Trump's illegal executive orders. If the government doesn't comply, then judges may find them in contempt. And one thing you'll notice about everything that we're talking about here today is that this is a slow process. Courts have to lay a factual and legal foundation, and they have to slowly ratchet up the pressure over time. If they don't lay the correct factual or legal foundation, or they move too fast, then all of their decisions might get overturned on appeal. But generally speaking, contempt of court is defined as any act which is calculated to embarrass, hinder, or obstruct a court in the administration of justice, or which is calculated to lessen the authority or dignity of a court. And when distinguishing between the types of contempt, there are two broad categories: criminal versus civil, and direct versus indirect. Now, civil contempt is remedial rather than punitive, and serves only the purpose of the party litigant, and is intended to coerce compliance with an order of the court or to compensate for losses or damages caused by non-compliance. When civil contempt is at issue, the party moving for a contempt finding bears the burden of showing by clear and convincing evidence that contemptors violated a specific and definite order of the court. And there are two types of civil contempt. Coercive civil contempt aims to compel someone to comply with a court order rather than punishing them for disobedience. The court imposes sanctions like fines or jail time to pressure a party into obeying the order, and the contemptor in a coercive civil contempt action is said to possess the keys to their own cell, because they can immediately end the sanctions with simply complying. The classic example is a witness who refuses to testify despite a court order. That person may be jailed until they agree to testify. And the other kind of civil contempt is called compensatory civil contempt, where the purpose is to award compensation to the party harmed by the contemptuous behavior. For example, if a company violates a court order and causes financial harm to another party, the court may order the violator to reimburse the injured party for the losses. But like private parties, government agencies and officials may be subject to civil contempt. But if the initial burden is met, then the burden shifts to the contemptors to demonstrate why they were unable to comply. Now, Trump officials have been held in civil contempt of court before. In 2015, the Obama Department of Education fined Corinthian colleges $30 million for defrauding students and misusing federal funds. A court directed the Department of Education to stop collecting on the loans, but when the Trump administration took over, the Department of Education continued to bill the 16,000 students who Corinthian defrauded. Education Secretary Betsy DeVos defied a court order to stop collecting student loan payments. And a federal judge ruled that, quote, there is no question that defendants violated the preliminary injunction. There's also no question that the defendants' violations harmed individual borrowers who were forced to repay loans either through voluntary actions or involuntary methods, offset from tax refunds and wage garnishments, and who suffered from the adverse credit reporting. Defendants have not provided evidence that they were unable to comply with the preliminary injunction, and the evidence shows only minimal efforts to comply with the preliminary injunction. The court found DeVos in civil contempt and fined the agency $100,000, which was paid to the impacted students. Now that takes us to criminal contempt. The primary aim of criminal contempt is vindicating the authority of the court. To prove criminal contempt, the court must show that a clear and specific court order was in place and the contemptor knowingly and willfully violated the order. Since criminal contempt is punitive in nature, the standard is beyond a reasonable doubt. And the court's authority to impose criminal contempt sanctions come from Rule 42 of the Federal Rules of Criminal Procedure. Rule 42 states, any person who commits criminal contempt may be punished for that contempt after prosecution on notice. And criminal contempt of court is generally recognized as direct or indirect, depending on where and how the contemptuous behavior occurs. Under Rule 42A, contempt is indirect when it occurs out of the presence of the court, requiring the court to rely on the testimony of third parties for proof of the offense. If this is the case, the court must hold a separate hearing to determine whether the contempt occurred. For example, if someone failed to pay court-ordered child support, this would be indirect because the failure happened outside of the courtroom. And the same is true if someone failed to turn over subpoenaed documents or disobeyed a restraining order, but contempt is direct when it occurs under the court's own eye and within its own hearing. The judge can immediately see or hear the contemptuous behavior and can punish it immediately. Direct contempt includes exactly the type of conduct you would expect: a witness openly refusing to answer a judge's questions, or a party disrupting court proceedings with outbursts.
One more word out of you, Mr. Reed, and I'll hold you in contempt.
I hold myself in contempt!
And here, regarding the case of the putative Venezuelan migrants who were renditioned to El Salvador, if Judge Boasberg is considering criminal contempt to punish the government, then he would have to weigh whether the government's actions were direct or indirect. The failure of the government to turn the planes around happened outside of his courtroom, so it would qualify as indirect contempt. However, I suppose that there's an argument that the DOJ lawyers were in contempt of court because some of the contemptuous conduct occurred inside of the courtroom. The parties took a break to determine whether the airplanes had already taken off, and the judge orally told them to turn the planes around, and the lawyers indicated that they would comply with the order. But direct contempt provides for summary disposition. No federal court is going to punish the government without a full hearing, especially since the government will appeal any contempt order. And it's better for all parties to have a complete factual record justifying whatever the court decides to do, whether it's civil or criminal. The problem is that the government is trying to prevent Judge Boasberg from undertaking the fact-finding necessary to develop a complete record about the flights to El Salvador. The judge has repeatedly asked the government to answer questions, but the government has refused to provide any answer. And then, sensing that Judge Boasberg was moving closer to a contempt finding, the administration suddenly claimed it was considering invoking the state secrets privilege. This prompted a new round of back and forth between Judge Boasberg and the government, which finally ended with the government asserting it had a national security reason to refuse to answer any questions about the flights. But it certainly seems like the administration's privilege argument seems to be made in bad faith. They didn't raise it until the judge continued to investigate, and a lot of the information about the flights is already in the public record, including a bunch of propaganda videos that they made at the time, and the first reference to privilege came from a declaration by an ICE official in a regional office in Texas who would not have been privy to any cabinet-level discussions. Now, Secretary Rubio, AG Pam Bondi, and DHS Secretary Kristi Noem say that the information about the flights must be kept secret for sensitive national security reasons, and they claim they can't even show it to the judge in camera, meaning privately in chambers, because Trump's policy goals must never see the light of day. Of course, irony of ironies, they made these arguments just days before Secretary of Defense Pete Hegseth and other high-level cabinet members leaked active war plans by including the editor-in-chief of The Atlantic in their Signal group chat. And then they claimed none of that information was classified or sensitive national defense information. Now, notwithstanding the onslaught of scandals coming out of the Trump administration, state and federal officials rarely screw up so badly that a judge finds them in criminal contempt. But when a public official flouts the courts and inflicts serious damage on other people, the courts often have no choice. For example, former Maricopa County Sheriff Joe Arpaio established a policy and practice of racial profiling Latino drivers and asking them to prove they were legally entitled to be in the country. A federal judge ruled the policy was illegal, but Arpaio directed his deputies to ignore the court and continued to racially profile drivers for 18 months. The sheriff's office illegally detained at least 171 people, and the federal judge referred Arpaio to the Justice Department for contempt. The U.S. Attorney's Office prosecuted Arpaio for criminal contempt in violation of 18 U.S.C. 401. That law gives federal courts the power to use criminal contempt to punish obstruction of justice. And a judge convicted Arpaio of misdemeanor contempt because he repeatedly and intentionally interfered with the administration of justice. Now, the Supreme Court has long held that a president cannot pardon someone for civil contempt, but he can pardon criminal contemptors. And unfortunately, before the court could sentence Arpaio, Trump pardoned him. And in fact, this was the first time President Trump exercised his pardon power. But a person prosecuted for criminal contempt is entitled to a jury trial. So what if Judge Boasberg referred a criminal contempt charge to the U.S. attorney for prosecution, and the U.S. attorney declined to prosecute? Well, theoretically, Rule 42A gives the judge the right to appoint special prosecutors. The rule says, quote, "The court must request that the contempt be prosecuted by an attorney for the government unless the interest of justice requires the appointment of another attorney. If the government declines the request, the court must appoint another attorney to prosecute the contempt." Although such prosecutions are rare, federal courts have affirmed that judges have that right. Now, in addition to contempt, federal courts have broad authority to sanction attorneys and parties who fail to follow court orders. The federal rules of civil procedure allow the courts to impose sanctions on parties who ignore discovery obligations, like refusing to respond to requests, failing to produce documents, or not cooperating with depositions. And Rule 11 of the Federal Rules of Civil Procedure allows courts to sanction both lawyers and parties for submitting improper pleadings, motions, and other papers. Sanctions can include fines, non-monetary directives, and attorney's fees. And in fact, we recently discussed Rule 11 in our video with Kel McClanahan in the battle over Doge. McClanahan and the National Security Counselors moved for sanctions after DOJ lawyers misrepresented that employees didn't have to respond to OPM emails, which turned out to be a lie. Although we get a lot of grief, lawyers are officers of the court and are not allowed to lie to the court.
A liar? Oh, I'm sure you don't mean a liar.
Well, he wears a suit and goes to court and talks to the judge.
Oh, I see. You mean he's a lawyer.
And in fact, Kel was the first lawyer to seek sanctions against government lawyers during Trump's second term. But I think we can expect to see a lot more of that now that the DOJ lawyers have their marching orders directly from Trump and Bondi. And speaking of which, we've started to see a trend where in case after case, the government lawyers can't answer basic questions from the court, either because they legitimately don't know the answer, or worse, when their client has instructed them not to answer. Honestly, it's a pretty interesting development, because along with this trend of sending incredibly junior people to argue in front of the courts, it's coupled with incredibly senior people like the Attorney General herself signing the pleadings. And when any lawyer signs a pleading, they are responsible for the fact and law that is cited inside of that pleading. So I would not be surprised if judges get incredibly fed up with the underlings not knowing or refusing to answer these questions and start hauling in the more senior people who have signed these pleadings. Now, in instances where a court needs to enforce an order, who's responsible for enforcing those court orders? Well, theoretically, the U.S. Marshal Service is the enforcement arm of the federal court system, and you've probably seen them portrayed as the government's bounty hunters.
What I want out of each and every one of you is a hard target search of every gas station, residence, warehouse, farmhouse, hen house, outhouse, or doghouse.
But the marshals have the ability to arrest people who do not comply with court orders, and every now and then the marshals are ordered to enforce a court order of national significance. After the Supreme Court's ruling in Brown v. Board of Education that declared school segregation unconstitutional, President Eisenhower deployed U.S. Marshals to enforce desegregation orders and safeguard students from violent mobs throughout the South. Photos of the events are printed in virtually every U.S. history textbook. So the marshals serve the courts, but the Attorney General also has authority to supervise, direct, and control the operations of the marshals, which means that Attorney General Bondi might be able to step in and order the marshals not to enforce a court order to jail a federal official. But who knows, maybe a defiant marshal would challenge her. And I think we all know who the right man for the job is.
I'll kill 4 of you before you even clear your weapons, and I'll take my chances with the other 2. And you see this star? That's going to make it legal.
But if Raylan Givens isn't available, there isn't one neat trick that could compel the DOJ to enforce the law against itself. However, the judge might be able to deputize someone outside of the Marshal Service to do it. Rule 4.1a of the Federal Rules of Civil Procedure outlines the procedures for serving certain types of process on the intended recipient. Quote, process must be served by a United States Marshal or Deputy Marshal or by a person specifically appointed for that purpose. Process here just means legal orders requiring an individual to appear in court. And the rule might allow the court to appoint someone else to serve its orders. Section B of the rule says enforcing orders committing for civil contempt. An order committing a person for civil contempt of a decree or injunction issued to enforce federal law may be served and enforced in any district. Any other order in a civil contempt proceeding may be served only in the state where the issuing court is located or elsewhere in the United States within 100 miles from where the order was issued. Any other order in a civil contempt proceeding may be served only in the state where the issuing court is located or elsewhere in the United States within 100 miles from where the order was issued. Now, Section B doesn't say that only marshals can enforce orders, so it is theoretically possible that Rule 4.1 allows the court to appoint individuals other than the marshals to enforce civil contempt orders. But this has not happened during modern US history, so we have no idea how this would play out. If a judge deputized a law enforcement officer and tasked that person with arresting Marco Rubio, what would happen then? We have no idea. Maybe Rubio refuses to open the door. Maybe AG Bondi orders the marshals to arrest the officer. Maybe there's an armed standoff. But we do know that there would definitely be years of litigation figuring out this whole mess. Now, all is not lost. The courts aren't the only branch of government that can stop a tyrannical president. The legislative branch also has a responsibility to ensure that a president complies with court orders. As we've talked about a lot, Congress has the power of the purse, and it could impeach Trump right now for illegally impounding the money it has appropriated, which President Trump is currently doing a lot. And that's what happened in 2019 when the House of Representatives impeached then President Trump. You might remember, according to the impeachment inquiry, President Trump withheld nearly $400 million in congressionally approved security assistance while pressuring Ukrainian President Volodymyr Zelensky to announce a criminal investigation into the Biden family. But I probably wouldn't hold my breath for an impeachment inquiry the second time around. But when Democrats controlled the House, they held hearings about Trump's actions and issued subpoenas to Trump staffers. These hearings exposed what Trump tried to do to Ukraine. Now, the Senate did not convict Trump and he remained in office. However, in the face of intense congressional scrutiny, Trump eventually caved and released the military aid. So I have good news and bad news for anyone who doesn't want a Republican or Democratic president acting above the law. The good news is that Congress is capable of holding the president accountable. The bad news is that Congress is currently controlled by one party, and they've given no indication that they would challenge Trump even when he usurps legislative power. So, is this a constitutional crisis? Yes, it very clearly is. At this point, the question isn't, is it a constitutional crisis? The question is the constitutional crisis over and did we lose? When the government defies the courts, there are serious and potentially irreversible consequences for the people who are impacted by Trump's lawlessness. At this point, we know the government violated court orders in the JGG Venezuelan deportation case. But what options are available to Judge Boasberg? For any kind of contempt hearing, the judge must identify the officials who are in contempt for failing to follow his order, and this is why he wanted detailed fact-finding. When did the lawyers relate his oral order to the people who could turn the planes around, or prevent the planes from taking off? Who did they notify? Who ultimately made the decision for the planes to land? As details have emerged, we now know that 2 of the flights landed in Honduras 2 hours after the hearing ended. And then they continued to El Salvador. Presumably, once the planes had landed and refueled, they could have turned around and gone back. And that's certainly what Judge Boasberg thought. But the government brazenly and probably falsely claimed that the court's order no longer had validity when the flights were outside of US airspace. The government defied the court order by continuing to send the flights to El Salvador. Ultimately, the responsibility for that decision may mean that Secretary Rubio would be found in contempt of court, but would this be a criminal matter or a civil one? In the DeVos case, she was the Secretary of Education and she did not order the department to stop collecting on fraudulent loans. So the court knew exactly who to go after. When DeVos sent the notices to the borrowers, over 3,000 of them made at least one payment on debts that they did not owe. So the court's monetary fines redressed the harm caused to the borrowers who paid money to the government that they should never have paid. But Judge Boasberg has a much more complicated task. Is civil contempt the right tool in this situation? Part of the problem with renditioning people to a supermax prison in El Salvador with no due process, no hearing, and no evidence is that it's not even clear that they should be there in the first place, and it's not clear by what terms they can come back. And we don't even know whether the US still has jurisdiction over them. Although I would argue that in theory, the government does have control over them since they're incarcerated as part of a $6 million deal between America and El Salvador. If America can pay El Salvador to house prisoners, then you'd think that they'd be able to get them back. At least this is what I'd be arguing if I was representing the deportees. Now, maybe the judge could fine Rubio in civil contempt and assess a monetary fine for every day he doesn't return the prisoners to the United States. I'm sure the government would appeal, and then we'd hopefully find out whether a court order could get them to be returned. But the other option is criminal contempt. And who would be in contempt in this scenario? It would probably be the official who willfully ignored the order, including Rubio, the Department of Justice lawyers, or maybe even the ICE officers who were consulting with the lawyers, if that's what happened. But if the judge opts for criminal contempt, then there'd have to be a separate hearing and there could be a criminal referral, which would then go back to the Department of Justice itself. And another drawback to this option is that President Trump could pardon these officials, just like he did with Joe Arpaio. But that's potentially a major reason why the court might opt for civil contempt. Trump would not be able to pardon an official who was guilty of civil contempt. Now, it's particularly interesting to see how the media has covered all of this. Now, you might have heard of Dr. Alawaya from Brown University, who was deported to Lebanon. And when the Trump administration ignored court orders and deported her anyways, 219 news sources covered it, with about 40% of the coverage coming from the left, 45% from the center, and only 15% coming from the right. And when you examine the headlines, you see some very different frames emerge that shape how readers interpret and understand the events that are unfolding. On the right, the most common theme was to emphasize that Dr. Alawaya attended the funeral of someone related to Hezbollah, even outright accusing her of being pro-Hezbollah, like we see here. On the left, we see a very different frame, as nearly every headline stresses that Dr. Alawaya is an Ivy League professor, and then from the center, sources were most likely to use the phrase despite having a visa, which implicitly argues that this violation is more serious than ignoring a court order. But the headlines you read first have immense power to shape how you understand the news, and that's why I like to get the news from as many angles as I can, which I do with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now, they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. These can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like the related story of the government claiming that Dr. Alawaya had images on her phone that were sympathetic to Hezbollah, whatever that means. Only about 25% of the source's reporting came from the left, 15% from the center, and 60% from the right. And this type of analysis often helps explain why we often talk past each other and why some people seem hyper-focused on what to others seems like nonsense or fake news. And this is all why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more LegalEagle, or I'll see you in court.